The broadcast is now starting. All attendees are in listen-only mode.
All right, welcome everyone to today's Title Topics webinar. These are ALTA's free presentations offered every month on issues important to title professionals. I am Jeremy Yohe, ALTA's Vice President of Communications, and today we have a great webinar lined up to help you understand California's sweeping data privacy law set to go into effect in January 2020. And while this may only have effect on limited number of member companies now, many states are really starting to take up this issue and will really kind of gain traction over the next year. Before starting, I need to touch on a few housekeeping items. A copy of today's presentation can be downloaded from the GoToWebinar handout section. All participant lines are muted for the presentation. If at any time you have a question, please submit them through the questions box, and we will hold some time for Q&A at the end of the presentation. Also, I did send an email to everyone who registered about an hour ago, so if you're only logged in through audio, you should have that in your email box as well. We need to thank Fidelity National Title Group for sponsoring our Title Topics webinars this year. Their support allows us to continue providing these educational opportunities free of charge. And with that, let me please introduce today's speakers. We have the pleasure of having three experts from the law firm Mayer Brown join us today. First, we have Stephanie Duchesne. Stephanie is a partner in Mayer Brown's LA office and a member of their insurance group. Next, we have Kendall Berman. Kendall is a cybersecurity and data privacy counsel in the firm's DC office. And also join us is Lei Shen. Lei is a partner in the cybersecurity and data privacy in Mayer Brown's Chicago office. And we also have the luxury of having Elizabeth Riley. Liz is senior privacy counsel for Fidelity National Financial, and will be offering some great insight into how the CCPA applies to everyone on the webinar today. And I'm trying not to cough. And Liz is also chair of ALTA's Data Privacy Executive Committee, so she's going to offer some great insight in addition to all the experts from Mayer Brown. Stephanie, with that, I'll turn the presentation over to you.
Great. Thank you so much, Jeremy, and thank you for having us. And you can see there's the three of us there. You'll hear all of our voices as we go through. If we can click on to the next slide, this is our disclaimer slide. This presentation is not to be considered legal advice. And if anybody has questions, we are, of course, open to those. I think Jeremy's going to hold those until the end, and if we have time, we'll answer them. But if our emails are on the front page here, so if you want to contact us afterwards, please feel free. So here's the agenda for today's discussion. We're going to talk a little bit about the origins of the CCPA and how we got where we are. It is important to the discussion and sort of the implementation timeline to understand the background. Then we're going to go into the essential components of the CCPA, the definition, who it covers, what it covers. We're going to talk a little bit about the requirements of the CCPA, and that is what rights it creates and what the corresponding business obligations are. We're going to go into some of the trickier aspects that we've been advising clients on in this space, the exemptions and the enforcement. And as Jeremy alluded to in the introduction, the sort of further changes on the horizon, both with the CCPA, if you can believe it, there is a 2.0 version already being floated. So with the CCPA and with other state laws that are likely to, other states that are likely to follow suit. And finally, we're going to talk about practical steps that can be taken right now to get businesses that are subject to the CCPA into compliance. So the origin story behind the CCPA. We can click on to the next slide. So California has a long history with protecting privacy. In 1972, it amended the Constitution to include an inalienable right. The right of privacy is an inalienable right. Over the years, there's been multiple privacy protection laws passed in California. And in March of last year, 2018, after the Cambridge Analytica scandal, There was a wealthy real estate developer in the Bay Area that sort of took it upon himself to really push for this privacy legislation, and really it was an initiative. It was announced in May of 2018, and he had backed it with his own money, that they had gotten enough signatures to add a privacy bill to the California initiative. And in California, we have direct legislation, and so those are going to be propositions that are put on the ballot, voted on in election. And if passed by voters, they're extremely difficult to change. If anybody on the call has had any experience with Prop 103 or any of the other propositions that have passed historically in California, they're very difficult, and the legislature cannot easily go in and amend it. So in order to, and we can click to the next slide, in order to avoid a situation where a extremely broad and comprehensive privacy law is passed by initiative and is not able to be amended by the legislature, there was a negotiation between the group that was pushing the initiative and the legislature. It happened very rapidly, and pretty much on the last day that they could push legislation through, there was a compromise, and that compromise is what we are sitting with now, the California Consumer Privacy Act. Immediately, the legislature began amending it, and this last legislative season has been very active in this space. We've seen a number of amendments pass the legislature for this year. They're awaiting signature on the governor's desk. He should be signing within the next couple days, and we expect that he will sign the amendments that passed. There were a number of amendments proposed that did not pass, some that were very broad, and the ones that passed for the most part, and we will be talking about them, were fairly narrow. Since between the passage in June and now, the AG has held public forums. That is part of what the AG's office has been required to do, as they will be the ones issuing regulations, likely in the next month or so, that help implement or are going to help businesses implement the requirements. So we are expecting those out this month. We can go on to the next slide. The CCPA is considered to be really the most sweeping privacy law in the U.S. It will be effective January 1st of next year. However, enforcement will be a little bit behind that. It will likely not be until July 2020. And we can talk a little bit about why that is. It's really 6 months after the AG issues the regulations, or July 1st, 2020, whichever comes sooner. So it's going to likely be July, but either way, the enforcement will be slightly delayed. And other states are possibly following suit. We've seen some activity in Nevada that we're going to talk about. There's other states that have been contemplating CCPA-like laws. So this may be the direction the rest of the country is going to ultimately go. And as I alluded to a little bit before, there is, just in the last about 2 weeks, a new ballot initiative proposed by the same group and backed by the same real estate developer that proposed the initial initiative that got us the CCPA. A new initiative is being proposed to, we're calling it CCPA 2.0. And we'll talk a little bit about that. Where that's going to lead is very much up in the air at this point. So we're just bringing it to people's attention as a new development. And we'll talk about that later in the presentation. So now we're going to move on to focusing on the CCPA itself and its key definitions. The 3 definitions that we are going to focus on that are most important to understand from a business perspective is who the subject businesses are, who's considered a consumer, and what is considered personal information. Kendall, I think that's, we're going to move on to you. Yeah.
Great. Thanks, Stephanie, and thanks, Jeremy. So just extremely broadly speaking, when you're thinking about who the CCPA applies to and if it applies to you, the answer CCPA gives is that it applies to businesses, as that's defined, that collect or determine the purposes and means of processing of consumer personal information. And as Stephanie said, the analysis of whether you are covered under CCPA or not really is focused on the definitions of those three terms: business, consumer, and personal information. Next slide. And so to begin, the definition of business that's provided under CCPA has two parts. And the first part, it defines business as essentially any legal entity that is organized or operated for the profit or financial benefit of its shareholders, that collects the personal information or determines the purposes and means of the processing of personal information, that conducts business in California, but it does not need to be located in California in order to be covered by CCPA, and then satisfies one of three threshold questions. Either the business has gross revenues in excess of 25 million US dollars, which is not only in California, but broadly speaking. Or two, buys, receives, sells, or shares the personal information of 50,000 or more consumers, households, or devices. Or three, derives half or more of its annual revenues from the sale of consumer personal information. And so if any of those three threshold considerations is true for essentially a for-profit entity that conducts business in California and processes personal information, the CCPA would apply. And I know, Liz, you have experience on this issue from a business perspective in terms of how to think about the definition of business, if you wanted to add in anything on that point now or later.
No, absolutely, Kendall, thank you. And just to speak, from the perspective of our industry as title insurance and abstract services providers, the definition of business warrants thoughtful consideration. Kendall, as she walked through the definition of business, there's so many thresholds, tests to be considered. And for us in the course of our business, even if we're not physically in California, we certainly may be engaging with California consumers in the context of providing title and settlement services, or maybe receiving California consumers' information in the context of providing those services. So I think it's very important to understand and to consider, with the advice of counsel, whether the law applies to you. If you have the question, are we or are we not, a covered business under the law? There's been concern or a rumor that engagement with a single California consumer in the context of providing title and escrow services, if you're outside the state of California, could alone trigger the law's application. And I think, as Kendall points out, it's a far more nuanced analysis than that, whether or not you're conducting business in California, as that's defined by, the definitions within the states, different bodies of law. Just an important consideration for our business. So the fact that you may come across one person's information who's a California consumer in the context of providing title or settlement services in Florida likely isn't going to get you within the scope of CCPA, but it's certainly something that, warrants close attention and, reasoned analysis to make that determination.
Thanks, Liz. That's really helpful. So moving on to the next slide. Oh, here we go. Excellent. So the CCPA does not stop there, though, in terms of what they define as business. There is a second part of the definition of business. So you can also be covered by the CCPA if you are an entity that controls or is controlled by a business that satisfies the definition in Part 1, and where you share common branding with the business. And the CCPA explains that this concept of control means that there's ownership of or the power to vote more than 50% of the outstanding shares, or any manner over the election of a majority of the directors or similar individuals, and a power to exercise a controlling influence over the management of a company. So if you are controlled by a business that is satisfied the CCPA threshold questions that we've just discussed, the next question you would ask is whether you also share a common brand, which isn't really clarified under the CCPA beyond what is a shared name, service mark, or trademark. So under this construct with these two definitions of business, there really is a way in which other companies can be pulled into what is covered by CCPA, even where they don't satisfy one of the three thresholds that Liz and I just spoke about. Next slide, please. So if you are covered as a business under CCPA, the question is then whether you collect or determine the means for processing consumer data. And consumer is defined in the CCPA as any person who's essentially a California resident. And this is one of the ways that CCPA was really a sea change in terms of how other data privacy regulations have addressed, at least in the consumer context, covered individuals for the purposes of their statutes. The definition of California resident is not specific to someone with whom you transact with, for someone who you are advertising, products or services for. It's a much broader definition. And in what we've learned now with the amendments, which we're going to speak to, is that it doesn't mean consumer at all. It can include employees, and it can include your business-to-business contacts. So it's important to know that the CCPA's construct of what is covered applies to California residents that go beyond, typically what you'd understand to be a consumer. And with that, Leigh is going to speak now about the definition of personal information on the next slide.
Thanks, Kendall. So keeping with the trend, the CCPA also considerably broadens what's typically considered to be personal information here in the United States. So previously, U.S. data privacy laws tended to have a really narrow definition of personal information. So for example, under state data breach notification laws, personal information was usually just certain sensitive personal information that would make an individual susceptible to identity theft, such as credit card numbers or social security numbers or other financial account information. But under the CCPA, it considerably broadens the definition of personal information. So now personal information is information that identifies, relates to, describes, is reasonably capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So what's interesting is that this definition is actually even broader than the corresponding definition under the EU General Data Protection Regulation, or GDPR. Under the GDPR, the definition really was just limited to information about an individual. But under the CCPA, this definition includes information that relates to a household as well. A few recent amendments have passed that are still awaiting the governor's signature, as Stephanie mentioned. Those amendments do help limit the scope of this definition. So first, the amendments added that the information must be reasonably capable of being associated with a person rather than simply capable of doing so, which is obviously broader. The amendments also clarified that publicly available information from government records is excluded from the definition of personal information. So previously, the CCPA had specified that such information would only be excluded from the scope of the CCPA if it were used for the same purpose that it was maintained and kept in the government records and the reason it was made publicly available. But now under this amendment, once data has been made publicly available by the government, it can still be used for any purpose and will be excluded from the scope of the CCPA. The amendments also clarified that de-identified or aggregated information is not subject to the CCPA. However, you need to be aware that the CCPA does have specific requirements in order for the information to actually be considered de-identified under the CCPA. And finally, to the great joy of many businesses, the amendments also excluded from scope employment-related information and business-related information. But the exclusion only lasts for another year. it actually sunsets in 2021. So if another amendment's not passed before then unfortunately this information will be back in scope. Next slide, please. So here are some examples of what the definition of personal information lists to be items that it considers to be personal information. And a lot of these are items that we don't typically think of as personal information, such as an IP address or an online identifier, an alias, commercial information such as purchasing history, your internet activity information such as your search history and browsing history, or information regarding your interaction with the website, and even inferences that are drawn from this information to create a profile. This is all now considered to be personal information under the CCPA. Next slide, please. So another important definition under the CCPA is the definition of sale, since a number of the obligations under the CCPA arise if you're selling a consumer's personal information. But of course, as with the other definitions that we've discussed, the CCPA's definition of sale is also much broader than what you'd normally think of as a sale. So specifically, a sale isn't just simply selling. It is selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating orally, in writing, or by electronic or other means, a consumer's personal information by the business to another business or a third party for monetary or other valuable consideration. So it's not just a sale that's for money, but also for other valuable consideration. And if you think back to law school, valuable consideration could be peppercorns. So the world of what's considered to be a sale under the CCPA is possibly extremely broad. The CCPA does specify some situations where the exchange of data would not be considered to be a sale. And those instances include if a consumer directed you to disclose the information to another party, or if you're sharing your information with a service provider to perform a business purpose, or if you are transferring the information as part of an M&A deal or bankruptcy. Next slide, please. So obviously the exclusion for sharing personal information with a service provider is something that many companies are going to be relying upon. But unfortunately, continuing with the trend yet again, the CCPA's definition of service provider is also not very straightforward. So specifically, a service provider is not simply a vendor who happens to be providing services to you and is processing personal information on your behalf. But in order to be considered a service provider under the CCPA, you actually have to include specific requirements in your contract with them, such as the requirement that they don't retain, use, disclose, or sell the personal information, and they can't use the personal information for other purposes and to provide the services to you. And there's even more contractual requirements that you have to include that are included in the definition of third party and the definition of sale. And it's important to include these restrictions because if your vendor contract doesn't contain these requirements, then the vendor is not considered to be a service provider under the CCPA. And technically, then your sharing of information with your vendor might be considered to be a sale, and then consumers can opt out of that sharing with your vendor. Now Stephanie will describe some of the requirements under the CCPA.
Thank you, Leigh. Yeah, so we're going to go through sort of the individual rights that the CCPA has granted to consumers and the corresponding business obligations. And this is very dense. There's a lot to it. So I'm not going to go through and read everything, but there are sort of larger categories to be thinking about. The first right that the CCPA gives consumers is what we're calling the right to know. And that's the right to know subject businesses' data practices, and also the right to know what the consumer's rights are under the CCPA. So what that means for businesses is that at or before the point of collection, they need to inform consumers about the type of personal information they're collecting and the purposes for which they are collecting this personal information. This can be achieved in many ways. Privacy policies with California-specific descriptions in them, put up on the website. I think the key point here is at or before the point of collection, which is probably the most challenging aspect of it, is how are you going to make sure you are letting consumers know what you're collecting about them before you collect it. And there are a number of requirements of what exactly needs to be in that notice. We have put some of them here, sort of listing the categories of PI collected, sold, and shared in the preceding 12 months. And we're going to talk a little bit about that 12-month period and what is being called a look back, and we'll talk about that in later slides. And disclose the sources from which PI is collected. So this is the notice that businesses need to provide to consumers so that they know what the business's practices are. And it's going to include information about the rights given under the CCPA, including the rights we're going to talk about next. So moving on to the next slide, the next right that the CCPA grants consumers is the right to access. And that really means the right to request from the business what information they are collecting on them. And it's not just categories like with the notice that needs to go out at or before collection. This is after collection. Consumers now have the right to go to a subject business and say, what specific pieces of personal information have you collected about me? And where did you get it? And who did you sell it to? And who did you disclose it to and for what purpose? And so this really creates a number of business obligations, the first of which is set out expressly in the statute, which is now businesses need to make available a means for consumers to make these requests. And that is including a toll-free number. There was a recent amendment that if you're an exclusively online business, you don't have to do the toll-free number, you can just do an email address. And so that's something that has alleviates some of this for some of our clients. The business then needs to respond to the request. So they need to disclose and deliver the requested information free of charge within 45 days and looking back 12 months. Again, that 12-month look back period that we'll discuss a little bit later. The business now has an obligation to verify that the consumer that is requesting their information is in fact the consumer. And so there will need to be some sort of verification process in place such that businesses are not providing, which is by definition, personal information to someone who shouldn't be receiving it. And there's various other aspects to it. It needs to be in writing, and you cannot require the consumer to create an account, and so on. So happy to answer any specific questions about that at the end of the call or in the future. Moving on to the next one. The next right that's granted is the right to opt out of the sale of the personal information to a third party. And Leigh was just discussing this. So if you are a subject business and you are disclosing information you have collected to a third party, that will, for most extents and purposes, be considered a sale under the broad definition, unless the party to which you are providing that information is your service provider. Which is why it's really important to go through that analysis, consider who you are disclosing information to, make them a service provider by revising your agreement with them such that it has all the necessary components in order for that entity to be a service provider, because otherwise the consumer has the right to opt out of that disclosure. And the business needs to respect that. It needs to not sell the person's information, and it needs to provide, again, a mechanism for consumers to do that opt-out. So it's a clear and conspicuous link on the website and a link in the privacy policy. And then there's a training component, so anybody that is responsible for handling these consumer inquiries needs to understand what the consumer's rights are here. And we discussed a little bit about how a sale does not occur when it's transferred as part of, transferred to a service provider or as part of an asset sort of in a larger transaction. Moving on to the next slide. The consumers are also given the right to delete. So the right to compel a business to delete personal information that has been collected about them. And the business obligation here is that the business must then delete the consumer's personal information from their records. This is one where, in my opinion, the exceptions follow the rule for the most part. There are a number of exceptions where a business does not need to delete the consumer's PI, despite the fact that they may be requesting deletion. I've listed a couple of them here. Certainly, if you're in a regulated industry, like many on the call are, you have to maintain records, and you can't just delete things if somebody asks you to. And so there's a number of exceptions that can be relied upon to avoid having to delete, but they do have the right to request it. And then the business will have to make a determination and go through that analysis on whether they need to do it or not. There finally is we have two more. So there's the right to not be discriminated against for exercising the rights granted under the CCPA. So what that means is that a business cannot discriminate against a consumer because they are choosing to exercise their CCPA rights. They cannot deny goods or services to that consumer. They can't charge a different price for the goods or services because that consumer is, not allowing them to use their PI or sell their PI. They can't provide a different level of service, and they can't suggest that the consumer is going to receive any of these things such that it would encourage the consumer not to exercise their rights. There is a bit of a exception or caveat here that the business can charge the consumer a different price or rate or provide a different level or quality of service if that difference is reasonably related to the value provided to the business by the consumer's data. Next slide. And finally, there is a private right of action. It is a limited private right of action, much to the relief of businesses. One of the amendments that would have greatly expanded the private right of action did not pass through the legislature. So there is a limited private right of action, essentially for data breaches. So if a business suffers from a breach of information that is either non-encrypted or non-redacted, then there is now the ability to get damages based on that. So injunctive and declaratory relief, and also statutory damages. So you don't need to actually prove harm. There's just a per incident damage amount, and that can add up to be quite high, as anyone that's ever dealt with statutory damages before knows. And a number of the exemptions that are under the CCPA do not apply to the private right of action. So if there is a data breach of GLBA information, for example, there's still a private right of action there, even though GLBA related information is exempt from the CCPA. Okay, next slide. I think, Kendall, you're going to be talking about some of the trickier aspects.
Sure, thanks, Stephanie. So, I think we gave you a lot of information, obviously, to digest about CCPA and the core rights that it creates and the business obligations. We're now going to spend a little time digging deeper on what we have found to be the trickier aspects of the CCPA for our clients. And we're going to start with the look-back period. As Stephanie mentioned, the CCPA requires that covered businesses disclose and deliver to data subjects requested information about them, the personal information that the business holds, to the consumer after they've been verified. And the information that must be shared with them is information that covers the 12-month period preceding the business's receipt of the verifiable consumer request. And so if you receive a request pursuant to CCPA that's been verified, as a covered business, you're obligated to essentially share all of the personal information that is covered by the CCPA that you have on them for the past 12 months, so for the past year. And the practical impact of that it can be difficult for some companies if they don't have the technical infrastructure that will allow for them to provide the information that it doesn't require them to retain information that they don't normally retain, but that they're able to identify and provide back that information in a technical way that makes sense given their business. And this is particularly important given that the CCPA comes into effect on January 1st of 2020. And so by those terms, the look back period would go back to January 1 of 2019. So, you know, in an ideal world, you'd have the systems in place in order to provide that information and fully comply with CCPA. Next slide. Okay, great. So it's been mentioned a couple times in the presentation that CCPA has been amended recently. And one of the key amendments that was a focus of the business community was to see if they could accept out of the coverage of CCPA information that pertained to employees. Ultimately, the amendment, which was passed and is on the governor's desk to be signed, exempts employee and prospective employee information from the CCPA, except for the private right of action and the notice requirement. And it has this exception for 1 year only. So this was a sunset provision essentially that passed in the form of the amendment that made the CCPA's rights that go beyond the private right of action and the notice obligation inoperative until January 1st, 2021, at which point it would come back fully covered by the CCPA unless further legislative action is taken. What this practically means then is that businesses that have employees in California and are covered by the CCPA will need to update their notice to employees describing the personal information that they collect about them, what they use it for, the categories of entities to which they share this information. They would need to basically comply with all of the components of the CCPA style notice for all of their employees and their job applicants. So that's one tricky area of the CCPA that's a little bit of a moving target, so that's why we included it to make sure everyone knows. The third area we wanted to emphasize, oh, and I'm sorry, Liz, if I talked past you on the look back period. I know you had some experience there with regard to some of the business challenges on that.
Oh, that's okay, Kendall. I think we can cover anything that I would have added there when we talk further about, you know, application and what steps to take to comply.
Okay, thanks. Okay, thanks. Great. So then moving to just the business contact information, this again was covered as an amendment to CCPA. Similar to what they did with employees, they created a limited carve out for business contact information, for personal information that is collected in the context of a business relationship. So with an employee, an owner, you know, some individual that's clearly associated with a business where you are conducting essentially a business transaction with them. So there is a carve out from the CCPA for that type of information that again becomes inoperative on January 1st, 2021, unless further developments happen to the CCPA, which we're going to get to at the end, can come through a variety of different ways. Next slide. Okay, so I think this is probably the trickiest aspect of the CCPA, at least it gets my vote, and that is understanding the definition of sale under CCPA. And I think part of the reason why this is so tricky is because the definitions in CCPA are confusing and vague, and also it really gets to the heart of what is, you know, of what CCPA is about, which is giving data subjects the right to opt out of the sale of their data. So as Leigh covered in her slides, the definition of sale under CCPA goes, you know, well beyond just a monetary exchange. Anything that is considered valuable consideration, you know, that the other side of the transaction is providing back to you would be considered a sale under CCPA. So you need to really evaluate your data transfers and understand whether anything would be within that scope of the definition. And then there's a definition of third party that the CCPA provides that is really so broad that it really only defines who's not a third party under CCPA. And primarily the way to be considered not a third party under the CCPA is to have an agreement with that party that puts the types of conditions on them that we see that is more similar with a service provider. So as we've laid out here, a sale does not occur where the business is directed by where the party is limited in terms of what they can do with the data, to the extent that they can retain it beyond the services of the agreement, to the extent that they can share it with other parties. It all needs to be in furtherance of that agreement. And that is true in order to be defined not as a third party, as well as to have a written agreement in place with service providers. So this is an area that I think is tricky, both because, again, of its breadth and the confusing way these terms are used within the CCPA, but also because each situation is unique to each business that's trying to comply. Next slide. Okay, great. So this is an area that I think is tricky in its own way, but it can be a useful tool sometimes in terms of thinking about your CCPA compliance. One category of information that is not covered by CCPA is so-called de-identified information. So it is useful to think whether there are categories of personal information that you use which can be de-identified and therefore can be removed from the scope of your CCPA compliance. So de-identified data is tricky in its definition in terms of the steps that a business needs to take in order to render that information de-identified. And it is often the case that different types of personal information require different types of steps in order to be properly de-identified. But the CCPA defines de-identified in a way that a business must take reasonable measures to ensure that data is not re-identified. So that can include, technical measures to separate the data in terms of how it's stored so that it cannot be re-identified with personal information, or to include those provisions within your contracts to make sure that it cannot be re-identified by another party and shared back with you, and to make no attempt to re-identify the information. So again, this can be a tool for CCPA compliance in order to reduce your scope, but you need to consider what data could be subject to de-identification, whether that data would be valuable or useful if it was stored in de-identified form, and whether this would be consistent with your business goals. But again, this is an aspect of CCPA that was also addressed by the amendments to clarify the definition of de-identified data. So we wanted to highlight it. Next slide. Okay, great. I think it's Lay is up.
Yes.
I believe, this section. Thanks.
So now we'll cover exemptions under the CCPA. And there are certain instances where the CCPA doesn't apply, but of course there's no simple answers here. The good news is the CCPA does allow you to comply with laws, yay. So if you need to share or not delete information or to comply with laws or to comply with a subpoena or to cooperate with law enforcement agency or to defend yourself in a lawsuit, then the CCPA will not restrict you from doing so. And if you use the information that's been appropriately aggregated and de-identified in accordance with the CCPA, as Kendall just described, then that information will also be excluded from scope. Next slide, please. But while a number of other laws exclude entire entities from their scope, such as financial institutions, the CCPA has only one entity-based exclusion, and that's for healthcare providers that are subject to HIPAA. And these healthcare providers are still only exempt if they treat all patient information as medical information or PHI under HIPAA. Next slide. So other than that one entity-based exception, all the other exceptions under the CCPA are information-based. So that means only the information that's subject to the GLBA or the DPPA or FCRA are excluded, but not the entire entity itself. So if you're a financial institution that's subject to the GLBA, you can still have more information that's subject to the CCPA. And I'll turn it over to Stephanie now to explain this in more detail.
Thanks, Leigh. Next slide. And I recognize that we're gonna pick up the pace a little bit here because I think people want to get to the practical steps at the end. So I'm just going to touch on this briefly. The Gramm-Leach-Bliley Act is it covers the non-public personal information of consumers and customers of financial institutions. So if you're a financial institution, which includes insurance companies and insurance brokers, or otherwise fit the definition of financial institution, you will know that, and you will know that you are subject to GLBA, and the CCPA exempts information that's collected pursuant to the GLBA from the CCPA. It's an acronym soup right now. So that is something that a number of our clients are able to rely on. Now, that doesn't mean that the business is exempt entirely from the CCPA. You will still need to be responding to requests. The response may be, we have no information that is subject to the CCPA to disclose to you at this time. We've also had a number of clients that as they're going through their data mapping and trying to really understand where they're collecting information from and for what purpose, start out saying, oh, well, everything we collect is subject to the GLBA. And then when they dig a little deeper, they realize, oh, wait, that's not really the case because the GLBA has much more limited, and we can go to the next slide, Jeremy, much more limited definitions, right? So a consumer under the GLBA, for example, is someone that is obtaining or seeking to obtain a financial product. If a business is collecting information about somebody that just stops on their website and makes no attempt to, buy a product or apply for a product or seek a service, then that person is not a consumer under the GLBA, but they still would be a consumer under the CCPA. So we can kind of keep moving. Liz, I don't know if you
I'll jump in here.
Yeah,
I'll jump in because the GLBA exemption is a very important one for our industry. As title insurance providers and providers of settlement services, we are considered financial institutions under GLBA. But as you pointed out, as Leigh pointed out, it's not entity specific, it's information specific as far as the exemption goes. And so understanding the interplay between GLBA and CCPA for us is going to require, a detailed analysis. The exemption is a welcome one because it does give us the opportunity in a lot of cases to be able to say the CCPA does not apply. But as you pointed out, there has to be that initial analysis of whether the information collected is collected pursuant to GLBA. So that the exemption does apply. And then in cases where it's not collected pursuant to GLBA, if, as you point out, it's online identifying information or other information that's under the broader CCPA definition, we've got to account for that and account for how we're going to respond to consumers if they make requests and we have collected that information about them. Something else to point out is that GLBA covers personal information provided to obtain a financial product or service for personal or household use. So, analysis as to whether you're collecting consumer information in the commercial context, which wouldn't be afforded the GLBA exemption, may be something that, entities in our industry will want to undertake.
Yes,
so it's a great exemption, but it's not a perfect one for us, unfortunately.
Right. It is a great exemption, but it's one that needs to be applied very carefully. And it's, as Leigh pointed out, and Liz, you did as well, it's information-based, not entity-based. And I've heard a number of clients come in and think that, oh, well, we're subject to the GLBA, so we're not subject to the CCPA. And we wish it were that simple, but that is not the case. So it's an exemption that many of our clients are relying on, but it is can only be relied on to a certain extent. And many clients are sort of, 90% of the information they collect would fall under the GLBA, but there's still that 10% that doesn't, and you need to think about what you're going to do then to, with respect to that information. The next slide, we've already touched on this in a couple other slides, so I'm not going to belabor it, but sharing information with a service provider is not a sale and therefore not something a consumer can opt out of. So the written contract, sort of the vendor agreement, your agreement that you have with any of your service providers, in order for them to truly be considered service providers under the CCPA, will need to include specific restrictions and requirements. And that's mostly about prohibiting what the service provider can do with the information that you are disclosing to them, and that they need to comply with your requests, such as deletion of data that are part of the CCPA. So if a business receives a request from a consumer to delete their information and an exemption to that deletion request does not apply, that will need to be passed down to the service provider level and have an obligation for the service provider to do so. We can move on. So I think, Kendall, that you were going to talk a little bit about further changes.
Yeah, and I'm going to spend probably just 2 minutes on this because I know that we have more slides to get to, and we've covered some of this in essence already. But one thing to look out for that will be significant is that the Attorney General will issue draft regulations. They were required to do this under the law of CCPA under certain specified topics, and can also move beyond those topics. And we are expecting those draft regulations sometime in the fall, whatever that exactly means. And then those won't necessarily be the final ones. Obviously, there'll be potentially room for further input and tweaking. But those are, I think, for most of our clients, really anticipated in terms of giving some additional direction on some of the tricky areas that we spoke about. If you could pass to the next slide and then the following one. We've already spoke about the amendment process, so I'm not going to belabor that anymore. One thing to just keep on your radar that Stephanie mentioned at the top is that there is now a CCPA 2.0 essentially that's been filed with the California Attorney General as a new ballot initiative. It's entitled the California Privacy Rights and Enforcement Act. It essentially builds upon existing CCPA and would, in most cases, be even tougher on businesses in terms of the obligations for data privacy. This will not be voted on, obviously, until November, and there needs to be a signature threshold to be met as well. So I think the points here are to note that this continues to be a very dynamic space in terms of California, just specifically California consumer privacy issues. And that, I think the experience around both the amendments and what we've seen with this ballot initiative is that, there's fewer opportunities, I think, to sort of position business against the sort of momentum that the consumer privacy drive seems to be heading in that direction. Next slide. We saw in 2019 quite a number of states that proposed comprehensive data protection legislation similar, but in some cases very different ways to CCPA. I think in 2020 there's no indication that there'll be anything but more of these statutes or legislation introduced. And the concern, I think, from most perspectives is that this is going to create, a patchwork of different requirements across the states, that it will be, in fact, different in some degrees between CCPA. And this goes to sort of a fundamental judgment call that we know companies need to make with regards to complying with CCPA at some point, which is, whether they apply these CCPA rights across the board to everyone in the sort of regardless of residence, or whether they specifically focus on California. A good sort of test case for this, next slide please, is the state of Nevada. They actually passed their own consumer privacy law after the CCPA, but it leapfrogged the implementation. The law in Nevada is actually in effect now, as of, I guess, 9 days ago. It is much more narrow in CCPA and in really almost every way. It only covers operators who own or operate an internet website or online service that is collecting information from consumers who reside in Nevada and have otherwise a nexus with the state. This is really an important thing to think about in terms of what direction other states will go. Certainly it's more narrow than CCPA. In effect, a lot of the ways in which people are sort of complying with or looking to comply with CCPA will cover Nevada in terms of if you're applying it to Nevada, but you can also elect to be sort of much more narrow and focused in terms of if you're covered by the Nevada law, how you comply with it. So I'm just going to leave it like that. There's of course more to say, but I know that we have a whole other section that's coming up.
Yeah, so we're going to dive into, in our last couple minutes here, practical steps towards compliance. These are the steps that businesses can be taking now to start ramping up or continue their compliance program efforts. We already touched briefly on this, that the failure to comply can be costly. There will be AG actions. Eventually, the AG will start enforcing this, and they can seek statutory damages for any violations. And then we talked about the private right of action, which is limited to data breaches, but can add up and be costly, particularly if there's a large scale breach. And Lei will talk a little bit about how this is a great opportunity to be reviewing data security plans in light of that. We can move on to the next slide. So, to the extent anyone on the call has done any work to ramp up for GDPR compliance, that can be drawn on to some extent. There are differences between the GDPR and CCPA in many respects, but they share sort of the same types of concepts in terms of creating rights. The consumer has rights to their own information, right? They own, in a sense, their own personal information, whereas before the paradigm was really the business owns it. And so there's overlap in that sense. And a lot of the pre-work, the data mapping, and the development of a privacy program with that in mind can be drawn on here for CCPA. So that's good news for those that are GDPR compliant or working towards GDPR compliance. Next slide, please. So one of the steps and one of the initial steps that we are working with a number of our clients on is really understanding data and understanding what data is being collected and, for lack of a better word, mapping where information is being collected from and how it's being used. Particularly considering whether it is being sold and whether any of the information is subject to an exemption. As Liz and I were discussing earlier, it's very important to parse out exactly what personal information, and understanding the definition of personal information is very broad, what information is being collected on California residents, and before you can understand whether an exemption can be used. So step one is really getting your arms around your company's data collection processes. Next slide.
I'll add a little bit here,
Yeah.
just from an industry perspective, and I will say this was a compliance effort that for a bit gave us pause because we were really trying to understand what data mapping really meant, for purposes of our organization. And I think it's both, there's a technical component and a non-technical component. I mean, it's essential to understand, to know what personal information you collect about California residents at locations where it's stored and the third parties and service providers you're sharing with. And while on, from the technical component, when the data is in our control, we can use, tools to identify what data we hold where, for what purpose we're holding it or transacting it. And there are also those non-technical pieces, though, and we found for us, it's been interview processes, it's been questionnaires to really understand kind of the data flow, what California consumer personal information we're receiving, in what context, from whom, and for what purpose, and then on the opposite side, who we're sharing it with and for what purpose. And in that, we really weren't able to, identify with a technical tool. That was a lot of discussion, interview, questionnaires. So if data mapping is a scary word, I mean, it was for us, but I think no longer is now that we understand kind of the context for purposes of CCPA.
Thank you, Liz. That's very helpful. The next step really then is to turn towards your privacy policies and your notices. As we've discussed, the CCPA has a, at or before the point of collection requirement for disclosure of the categories of personal information that are collected, sold, and disclosed, and providing notice of that to California consumers. The transparency here is regarding the rights conferred under the CCPA and its description of the methods for submitting a request for personal information or deletion requests. So the privacy policy is a very obvious place to put this in, and having that offered up at or before the point of collection, separate California rights specific notices. Some clients are doing that, but there has to be revisions or creations of privacy policies and notices to go out to California consumers. Leigh, I think you're going to talk about the last couple steps.
Yes, and I'll go really quickly because I realize we're out of time. So another step you'll want to do is consider whether you're actually selling any personal information to a third party, because if you are, you'll have to build in the ability to have the consumer opt out of that sale, among other things. But unfortunately, as we discussed earlier, there is a very broad definition of sale and what's considered to be a third party, so this step can get a little bit complicated. Next slide. As we discussed earlier, the CCPA does include a number of requirements that the service provider has to meet in order to qualify as a service provider. So you'll need to make sure that your contracts with your service provider actually contains these requirements, such as prohibiting the service provider from collecting, retaining, using, or disclosing the personal information for any other purpose. So you just want to make sure that you've captured all that with your various service providers who will have access to personal information. As Stephanie mentioned, the CCPA does have a right of action in the event of a data breach. So this is a good time to look at your incident response plan to make sure you can actually quickly detect and contain and mitigate a breach. The next slide. And finally, since there are so many new rights in place, you'll want to make sure that you have the appropriate policies and procedures in place to comply with the CCPA. So for example, you'll want to modify your existing internal privacy procedures to reflect the new rights that individuals have. You might want to develop a process to verify consumers. And you also want to train your employees on these new policies and procedures, especially any employees that'll be handling and fulfilling these requests. Next slide. Oh, I guess that's it. Not sure if we have time for any questions.
Well, this is Jeremy. If you all don't mind, just a few minutes answering some of the questions that have came in. So you guys did cover a lot. Thanks for providing the details about the CCPA and some of the great practical tips. So we've got the Attorney General as kind of the regulator. Are there any periodical reporting requirements and that companies that must comply that have to submit to the AG? Are they going to be having like people knocking on their doors, asking for proof of compliance? Any information you guys could provide about that?
This is Stephanie. I can jump in and then please, Kendall, Leigh, Liz, weigh in. So I am not aware of any proactive reporting on compliance requirements, but we are still very much actively anticipating the Attorney General draft regulations. So a lot is still TBD on what the Attorney General is going to be looking for in terms of what they're going to consider adequate compliance on a lot of these different aspects. And I'm not sure if anybody else, any of the other presenters have a different viewpoint on that. But yeah, they will. Here's my gut on this. The AG will absolutely move towards enforcement shortly after July of next year. My gut is that they aren't going to start in insurance or in title or escrow first. So there, you could take a breath there. This law was really directed and coming out of the big tech business in California, the Facebooks and all of that. And so I think if they're going to start somewhere and want to have a big splash, it would be there. I'm saying that totally as my own opinion, and that is not based on, anything other than my opinion, but I don't know if others on the call have thoughts.
Yeah, it's Kendall. I would just also add, I think there's a difference between the CCPA and GDPR, both obviously in terms of the letter of the law and what enforcement will look like. And I think with GDPR, there are actual, very clear affirmative requirements to have the type of internal documentation and policies and procedures, and the lack of those is a violation of, just on its own of GDPR and enforcement that really, runs the gamut, depending on the Data Protection Authority. I think with CCPA, there's not that type of requirement. Data mapping is an essential thing, essentially, to fulfill your obligations under CCPA. You can't do what CCPA requires unless you map your data. But unlike GDPR, for example, there's no requirement that you in fact map your data. So I do think that's an important distinction from an enforcement perspective.
All right. So TBD July, still do your due diligence and be ready. Liz, if you're still on the line, just maybe add a little bit more color. If I'm a title agent and I'm in Topeka, Kansas, or Norman, Oklahoma, Columbus, Ohio, and I have one-off transaction that involves a California resident, does this apply to me?
I think the complete answer would start with, consult with the advice of counsel whether or not this applies. But based upon the definition of business under CCPA, one, you would separately have to meet one of the thresholds, gross revenues, the collection threshold, sale. But more importantly, I think whether or not you conduct business in California is an operative phrase for anyone considering if they're physically outside the state of California and the determination of whether or not this law applies. And really there you're looking at definitions set by the California Corporations Code or the Franchise, Tax Board, both of which point to, having a business presence in California, which my personal opinion, if you have a handful of transactions for California consumers, you're not closing transactions for California properties, and you're physically outside of the state of California, you're likely not going to have a compliance obligation under the law.
Okay, awesome. Thanks for clarifying and giving a little bit more explanation. Just two more questions and we'll wrap up today. Lisa had asked if nonprofits are exempt.
I can take that one. It's Kendall. In effect, nonprofits are exempt. The definition of business applies to for-profit entities. However, there's a little wiggle room in that they don't explicitly say that nonprofits are exempt. And they say that any entity, let me try and get this exactly right here. Any entity that is organized or operated for the profit or financial benefit of its shareholders or other owners. So it leaves some room for interpretation whether there's a nonprofit out there that still its goal is operating for the profit or financial benefit of its shareholders. I'm thinking, for an example, a credit union.
Okay, always room for interpretation. One more, Randy had asked if the Act requires disclosure of PI, personal information, collected directly from the consumer. So if you're obtaining it directly from the consumer, do you still have to disclose that, I'm guessing?
If you're not collecting it directly from the consumer?
If you are.
If you are, yes, absolutely.
All right. Fantastic.
That is the heart of this. It also applies if you're not collecting it directly from the consumer.
Right.
But if you are collecting information directly from the consumer, yes, that still applies.
All right.
Everything applies.
All right. Well, fantastic. Again, thank you for giving the overview of the CCPA, and hopefully everyone on today's call got some great tips on how to comply come next year. If you missed parts of today's webinar, think others in your office would benefit from listening. A recording of the presentation will be available. You all will get an email tomorrow with a link, and all of our webinars are archived on the Alta website at alta.org/title topics. If you're looking for more resources on CCPA, you can go to Alta's webpage at alta.org/ data privacy. Looking ahead to next month, November 10th, we'll shift focus from regulatory compliance to talking about how you can grow your title business by mastering leadership communications. And with that, that will bring us to the conclusion of today's presentation. Thanks for hanging out with us for an additional 10 minutes. To wrap up, I do need to thank Fidelity once again for sponsoring our Title Topics webinars. Also, quick reminder, if you're a company, just because you're an ALTA member does not mean you're confirmed in the ALTA registry. So you'll want to go to alta.org/registry. Make sure you're confirmed in that. Again, thank you to the speakers for sharing your great insight on the consumer privacy issues. Take care, everyone.
Thank you. Take care.